there are two matters before the court this morning. One of them is a plaintiff's motion for protective order and sanctions. The other is a protective order for inadvertently produced discovery documents disseminated to a third party. Those are the two items that I believe are before the court this morning.
Your Honor, there's also Defendant Green's request to video this hearing.
The GR...
the GR-16.
Now, I didn't receive anything in writing, but I did get notification that there was going to be the request.
It was filed with the court, and it was served a judge's copy too. I don't know what happened.
I don't know either, but I'm going to grant the request. So,
thank you, Your Honor.
Yeah. Now, I might note though that the record of the case is through a court reporter, not through his video, and he has to understand that. But as a member of the media, and I'm not going to contest that at this point, he has the ability to video our process. Alrighty. Pending Mr. Hubie's appearance,
okay, I'm sorry to interrupt, Judge Hauser.
Fine.
I have a response from the email records request at Yahoo that says, Ms. Rocket, what is this? You are providing me notice of a hearing already happening. Chris.
Okay. I guess you can respond that if he wishes to make an appearance in the hearing, he can make an appearance at this point. We're providing him that opportunity.
Okay, he's in the waiting room now, so I'll go ahead and admit him.
Thank you. Good morning. Alrighty. I believe that we have Mr. Hupie now involved in the hearing as well. We are on the record in the cause number 19-116-981, two motions before the court, and both by, well, actually different. Pierce County's one and Plainfield is the other. What I'd like to do is take the first matter would be the request for a protection order for inadvertently produced discovery documents disseminated to a third party.
And Judge Hauser, I'm sorry to interrupt again. I just wanted to let you know I've been trying to unmute Mr. Huppy, but I'm having difficulty. I'm not sure if he's doing anything on his side to keep it muted, but I'm not having any luck unmuting him at this point right now.
Okay. Mr. Hubie, are you doing anything? Are you keeping yourself muted? Or is that just, oh, there we go. You might be there now.
Yes.
All right, thank you.
Okay, so I want to jump in here just a second. So why am I just now getting notice of this?
You're not just getting notice of it, you just got the invite to the hearing through this particular Zoom. I believe that you were, at least it's been represented to me that you were provided notice of the hearing through the voting process.
I haven't been personally served anything.
No, you don't have to be here then. You can be here, but you don't have to be. But I am going to take up the issue concerning the inadvertently produced discovery documents disseminated to a third party. And I believe that you might have some interest in that.
I have some interest in having you explain my motion to disqualify you.
You are not a party, so don't have standing. So we are going to go forward.
But you did make a ruling in that, so you assumed jurisdiction at some point.
Okay, I'm not going to discuss that with you any further. I've told you why that is not presently before.
Okay, so I have put objections on the record, so you are denying those objections? You're overruling?
I'm not sure exactly what objections those are.
So you're not familiar with the case file? Okay.
That's what I said. Don't put words in my mouth You said you made objections. If you want to make objections, make your objections.
They're on the record, Your Honor.
Okay, I'm denying them. All right, so let's go forward with the motion.
Thank you, Your Honor. This is Jayne Freeman. I represent defendant Pierce County in this matter. I think the first issue that you wanted to address is the county's motion for protective order regarding documents that had been inadvertently produced in discovery and then were disseminated to a third party, and the third party is Mr. Hoopy. We've previously had a hearing on this matter regarding the front end of this situation, and the court has previously ruled that the two documents that the county has referenced, the Bates number pages are in the record at 152 and 153, were inadvertently disclosed to the plaintiff in response to discovery requests. They should have been redacted. Immediately when it was discovered, I contacted plaintiff's counsel, which was Mr. Thomas, and notified him that 2 pages that should have been redacted did not get redacted. The court thereafter ruled on my initial motion, or the county's initial motion for protective order, and ruled that both Mr. Thomas, the attorney, and his client, Mr. Green, were ordered to immediately return and or destroy any copies of the 2 pages that they had, and to certify whether they had disseminated the 2 pages or the discovery documents, really the 2 pages were what was at issue, to any third parties. Thereafter, both Mr. Thomas and Mr. Green certified that they did destroy their copies of the inadvertently disclosed documents, but Mr. Thomas indicated he had already transmitted the discovery responses, including these 2 pages of documents, to Mr. Hoopy on his own within the first few hours after he received them from my office. I've had conversations with Mr. Hoopy and some email communications requesting that he voluntarily agreed to return the documents and destroy the documents. He has thus far indicated he will not do so without a court order. So we are here today asking that the court issue a protective order requiring Mr. Hoopy to destroy any copies of these discovery documents and not disseminate them any further, and to also disclose whether he has disseminated the documents any further. Given that we've already addressed a number of the issues that relate to this, a couple of things that are clear. Neither Mr. Thomas, his client, Mr. Green, or Mr. Hoopy ever would have had copies of these documents in their possession, but for the county having had to respond to discovery requests pursuant to the civil rules and the discovery rules that fall under the jurisdiction of this court. The court has discretion to fashion any orders related to those discovery rules to ensure the appropriate administration of justice. There's no reason that either Mr. Hoopy or even Mr. Thomas or Mr. Green ever would have had their hands on these documents, but for this discovery process. And the court has already ruled appropriately that an inadvertent mistake during the discovery process could and was immediately corrected by destruction and return of the documents. These are not the documents contain private information about a county employee. Mr. Hoopy would not otherwise be entitled to them. And in fact, Mr. Green or Mr. Thomas would not otherwise be entitled to them, even in the discovery process. That's why they were intended to be redacted. He has, in addition to the court's subject matter jurisdiction over the broad range of discovery processes, Mr. Hoopy also has moved to intervene in this case. He has argued that he is an interested party. He has not been granted yet the opportunity to intervene. There's been no ruling whether or not he is an interested party, but he has personally subjected himself to the jurisdiction of this court by requesting that he be joined as an indispensable party. And at least one of the other defendants, Mr. Green and his attorney, have supported that as well. That's still a disputed issue, but that's the position that Mr. Hoopy has taken with respect to this case. So we are asking that the court enter an order directing Mr. Hoopy to destroy the documents that were confidential discovery documents transmitted to him for no purpose and no good cause, and to preclude him from redisseminating or using the documents in any way.
Thank you. Mr. Thomas, do you have anything you'd like to add?
I don't believe that we're an interested party in this motion. We didn't file a response, Your Honor.
That's right, but I was just asking if you did.
Not that I know of, Your Honor. No, thank you.
Other counsel?
This is John Nicholson, counsel for the plaintiffs, Pierce County Prosecuting Attorneys Association, and Mr. Cornelius. And plaintiffs strongly support Pierce County's motion for obvious reasons. It is my client, Mr. Cornelius's confidential information that's at issue. And the county's counsel is correct. The court has subject matter jurisdiction over this type of case in the discovery process. And it also has personal jurisdiction over Mr. Hoopy, who has indicated he's a resident of the state of Washington and has asked this court for relief, and by doing so has waived any objections to the court's jurisdiction. So the court should grant the motion.
Mr. Hoopy, you have I sent out the links. You could be in the screen to hear what you have to say about this.
Well, if you think you have jurisdiction, which you possibly have subject matter jurisdiction, if you think you have personal jurisdiction over me today, then you had personal jurisdiction when you issued an order continuing my motion to intervene back in January or February. If at which point, then my motion to remove you under statutory authority was valid, and simply to ignore it. So without arguing whether or not Ms. Freeman's entitled to a protection order, we have to get past the fact that you have been removed as a judge in this matter. Ms. Freeman and Mr. Nichols have both vehemently opposed my my intervention in this litigation. I haven't been served the summons or complaint. And you don't have jurisdiction. And I'll say this: if you issue whatever order you're going to issue, I will file a notice of appeal right now on it.
Or you can always exercise whatever rights you'd like to exercise concerning.
Yeah, and plus, why am I just now attending this? Your staff apparently didn't think I was a party. Is that what Ms. Rocket said earlier?
I'm not sure that's exactly what she said, but right now you are not a party. That's what I'm saying.
Oh, okay. So, all right. So I'm not a party. Okay. I'll take that.
All righty. Anything further, Ms. Freeman?
Unless you have questions, Your Honor.
I don't. So I've been provided a proposed order granting defendant Pierce County's motion for protective orders for inadvertently produced discovery documents disseminated to third party. I've had an opportunity to review those documents. I believe that they're appropriate. However, there are some changes that need to be made. The parties appeared via Zoom. I'm going to make that.
Oh, I have a question, a kind of a housekeeping question. What clerk is taking the official record? A Kitsap County clerk or a Pierce County clerk?
The Pierce County clerk.
And who would that be?
I believe
Matthew Scamu.
Actually, the court reporter is Shamu.
That was the court reporter, or that was the clerk?
That was the court reporter.
Oh, who is the clerk that's taking the clerk's minutes?
I believe it's Miss Rocket.
Oh, is Miss Rocket a judicial assistant, or is she a clerk of the Superior Court?
Well, you're going to have to ask the Superior Court of Pierce County to tell you the truth.
So, just for the record, nobody is in Pierce County right now? You're in Kitsap County, sir?
I am in Kitsap County right now.
Okay.
And just for the record, I'll let you know that I am actually in my chambers in the Kitsap County Courthouse.
There was, Your Honor, I don't know if you caught it. Also, the other just administrative change in the order. It says it was drafted to say the hearing took place on February 21st.
Yeah, I see
So
that.
that can be changed to May 18th. Thank you.
What a sick joke.
And in the list of documents that were considered, it appears that the plaintiff did file a response after I had prepared this draft motion. I think that was the only response that was filed, or other responsive pleading.
Plaintiffs did file a response also in support of it.
I'm sorry, I didn't hear you.
The plaintiffs did file a response that was in support of the motion.
Of course, you both support
that's
each
what
other
I
all
was
the
referring
time.
to. I don't think there was anything else.
You're the same. One and the same, huh?
So, Ms. Freeman, then you represent the plaintiff?
Mr. Hupy, I'm going to have you not ask any more questions.
You're making too much sense, Mr. Hoopy. He has no good answer to anything logical.
Excuse me, there's somebody speaking and I can't see who it is. I don't know if I'm just taking it down, but I just want you to know that there's somebody speaking. It looks like Mr. Green is speaking, making comments, and
Oh, I'm sorry. I thought my channel. I thought my audio was muted.
no, it's not.
Oh well.
Alrighty. The order is going to include that Mr. Hupy is directed to immediately destroy any copies or versions of documents numbered PC 000-152-00153, produced by counsel for defendants Pierce County to Mr. Thomas's office on January 29, 2020, in response to Defendant Green's discovery request that he received from Mr. Thomas or Mr. Green, or received, obtained, or assessed from any other source. Documents, regardless of format in which they are maintained, shall be destroyed immediately, whether stored in hard copy, electronically, or in any format, or in any location. Mr. Hupy is directed to immediately refrain from publishing, disseminating, sharing, or disclosing in any format or medium copies or stored versions of documents, base number PC 000-152-000-153, or information or data contained therein, produced by counsel for defendant Pierce County to Mr. Thomas's office on January 29, 2020, in response to Defendant Green's discovery request that he received from Mr. Thomas or Mr. Green, or received, obtained, or assessed from any other source. And Mr. Hupy is directed to certify to counsel for Pierce County whether he has disclosed, published, disseminated, or shared documents dates numbered PC 000-152-000-153, or information or data contained therein, produced by counsel for defendant Pierce County to Mr. Thomas's office on January 29, 2020, in response to Defendant Green's discovery request that he received from Mr. Thomas or Mr. Green, or received or obtained from any other source with any other individual, entity, or location, and to produce contact information for each individual, entity, or location, and time and date of any such disclosure.
So are you issuing an order, Your Honor, that I'm now a party to this litigation?
I am not.
So I'm not a party. Okay.
Alrighty, I do find that there is personal jurisdiction over you because of your motion to intervene, but that motion to intervene has not yet been heard, and so you are not yet a party.
So,
Alrighty.
so how
That takes
do I
care
go
of that.
about?
That takes care of that matter. We'll go forward now with the motion in order for protection and sanctions.
May it please the court, again, this is John Nicholson for the plaintiffs, Pierce County Prosecuting Attorneys Association, and Mr. Cornelius. This motion was necessitated by events that occurred back in late January, and it was the plaintiff's desire to get this addressed as soon as possible, but the combination of having this matter assigned to a visiting judge, which gave us limited hearing dates, and then delays associated with the partial shutdown of the courts from the coronavirus outbreak prevented it from being heard until now. But it remains very important to the plaintiffs that something be done to make certain that the situation that this motion addresses doesn't happen again. As the court is aware, I represent an individual plaintiff, Mr. Cornelius, as well as the Pierce County Prosecuting Attorneys Association. The association is a union and it's a corporate entity. Scott Peters is the president of that association, and he is the speaking agent for the organization. On the morning of January 24th, I learned that when Mr. Peters was on the elevator going back to his office, he was accosted by Mr. Thomas, who was with Mr. Green, and he was being filmed and recorded without his permission. Mr. Thomas asked Mr. Peters his name. It was evident that Mr. Thomas already knew who Mr. Peters was because Mr. Thomas stated the name before Mr. Peters did. Mr. Peters was demanded to show his ID badge. I would note that one of the central issues in this lawsuit concerns whether or not Mr. Green, and by extension his attorney, has a right to inspect ID badges of deputy prosecuting attorneys. Mr. Thomas asked Mr. Peters other questions, including questions about the association's fundraising activities to finance this lawsuit. And as my client exited the elevator, Mr. Thomas yelled at him, "Don't lie to me," when he denied any knowledge about meetings about fundraising. And so this is all in a video that Mr. Green has put on his YouTube channel, which we've submitted to the court for it to review. Mr. Peters was distressed by this incident and contacted me about it immediately after it happened. And I then immediately emailed Mr. Thomas. Exhibit 6 to my declaration contains the series of emails that Mr. Thomas and I had that day about this. My initial email described to Mr. Thomas what I learned from Mr. Peters, and I demanded that it stop. The response from Mr. Thomas at that time did not dispute any of the facts that I raised with him. He didn't dispute that he knew who Mr. Peters was or that he was the president of the association, nor could he. Mr. Peters was the subject of prior discovery requests that Mr. Thomas, on behalf of his client, had propounded to us, and Mr. Peters verified those same responses on behalf of the association. And so there was no question about who Mr. Peters was or that he was the speaking agent for my client. What Mr. Thomas implied in this email exchange was that the interaction he had was permitted because Mr. Peters was working as a prosecuting attorney at the time of this interaction and was not doing the business of the Pierce County Prosecuting Attorneys Association. And you can read in the exchange, Mr. Thomas states, "I interacted with DPA Scott Peters. I did not interact with PCPAA President Scott Peters." And so based on that, there was a refusal to acknowledge any kind of wrongdoing or mistake here, much less to give any assurance that this type of contact with my client would stop. And so now, in the response that's been filed with the court, Mr. Thomas seems to have abandoned that argument because it definitely is wrong. Clearly, the strictures of RPC 4.2 aren't dependent on what particular task a person is performing at the time a lawyer has ex parte contact with them. Under the rule, a lawyer is precluded from having ex parte contact with a represented adverse party, period, regardless of what that party is doing at the time of the contact. So Mr. Thomas's response now is that it was his client and not he who had this ex parte contact with Mr. Peters, and more specifically, he claims it was his client and not he who demanded that Mr. Peters show his ID badge in the elevator. That was not stated at the time that I initially confronted Mr. Thomas about this situation, which is one reason why it's not a credible explanation. If this were true, Mr. Thomas could have simply stated that on January 24th when I emailed him, and he didn't state anything of the sort. Another reason it's not a credible explanation is that it's inconsistent with how Mr. Green labels the video and describes what's happening in the video in text that is in the video. The text indicates one of Pierce County's unaccountable, immoral attorneys called out in public for hiding his identity by a heroic ethical attorney.
Absolutely.
The ethical attorney referred to obviously as Mr. Thomas. Mr. Green is not an attorney. So Mr. Thomas and Mr. Green are now pretending that this is not how it happened, but simply put, Your Honor should not believe them. and the video makes this clear. But even taking this new rendition of the facts about who asked about the ID badge, it really doesn't even matter. Mr. Thomas doesn't dispute that he then proceeded to ask my client about additional questions, including fundraising for the association for this lawsuit, and then went so far as to call him a liar as he exited the elevator while he was being filmed without his consent and without his attorney present.
In a public building.
And so no matter how you cut it, what happened in this elevator was appalling, and it was a violation of RPC 4.2. And when I confronted Mr. Thomas about this, his response to the situation really makes matters even worse. Because rather than simply conceding that this went too far and shouldn't happen again, Mr. Thomas instead concocted a bunch of excuses and accusations against me, suggested that I and my clients are lying in their discovery requests based on some kind of half-baked argument about a objection to one of his discovery requests. Again, there was no question about who Mr. Peters was and what his role was. And there was no assurance that this would not happen again, and that's why we had to bring this motion. We were forced to seek court intervention to end this, or simply accept that this type of harassment might occur in the future. So ordinarily, RPC 4.2 would be sufficient to ensure that this sort of thing doesn't happen, but when there are questions about what counsel's obligations are, or there's been a violation of those obligations, the court does have jurisdiction and the authority to enter a protective order enforcing the rule, and that's what we're asking for here. The court should enter a protective order specifically stating that Mr. Thomas or any other attorney retained by Mr. Green is prohibited from having further ex parte contact with represented parties. We are also asking for sanctions. As I mentioned, we had to bring this motion because there was no acknowledgement of any kind of wrongdoing, nor any promise not to repeat this type of behavior. The court has the inherent equitable power to manage and control litigation, and that includes the ability to impose sanctions if it makes an explicit finding that there's been bad faith and an improper knowing ex parte contact has previously been held to constitute bad faith under this line of authority, and that would be the State versus Merrill decision, which was cited in our briefing. The reporting itself, in my view, shows bad faith without the need for any more evidence, but the way that counsel conducted himself in responding to this once I raised it with him makes it abundantly clear. So at the very minimum, the court should award the plaintiffs their reasonable attorney's fees for having to bring this motion. Unless the court has other questions, that's what we're asking for, a protective order and sanctions consisting of attorney fees.
Yes, I do have a question. Let's just say for this question that it is Mr. Green that asked the question about the identification badge rather than Mr. Thomas. Does that make a difference?
No, it doesn't, Your Honor. I noted in our, I believe it was the reply brief, that the rules also make it improper for an attorney to violate the rules through the conduct of another. And so by being there and not merely acquiescing by not stopping this from happening in his presence, but then going further and asking more questions that were improper, and that's not even disputed, the incident about asking about the fundraising and then calling my client a liar, it's not even disputed that that happened. So my answer is no, that does not make a difference.
Okay, thank you.
Yeah, Your Honor, I have a question. I realize I joined
Who is
late.
this? Who is this?
This is Chris Hoopy. I realize I joined late. Was everybody sworn in as witnesses? Did Mr. Nicholson swear? It seems like he was testifying there.
He made argument. Mr. Thomas, do you have anything to add?
Yes, I do, Your Honor. First of all, I would like Mr. Nicholson to play the entire video for this court and for the public to see what actually transpired in the video. The video is a part of evidence that Mr. Nicholson submitted. He testified that it's true and correct, and his argument relies solely on the video. I would like that to play in front of this court and in front of the public so that the public knows what I did and did not do. Mr. Nicholson, by his own declaration, testifies that it's true and accurate. He should play it in front of the court. It's his evidence that he submitted.
And I have not yet done this, but I will do this now. I received a copy of a DVD with his affidavit, and I have reviewed the DVD several times, actually. So I have that in my knowledge base.
Okay. Well, I'd like to start with some objections then to what Mr. Nicholson said. First of all, there's new arguments in plaintiff's reply to the motion that defendant Green didn't have a chance to respond to. First of all, they claim in the reply that it was Mr. Green who asked for Mr. Peters' ID badge. That was nowhere stated in the facts or anywhere in the moving papers. That's unfair to bring up in the reply. Plaintiffs or defendant Green did not have a chance to challenge that. There's different legal issues and a different analysis. Whether I asked for Mr. Peters' ID badge or whether Mr. Green does. That's a huge factual assertion in order to change, and that's the first objection. That's an ambush argument. It's on the reply on page 4, lines 14 to 16. Quote, Mr. Thomas's presence and acquiescence in defendant Green's contact with Mr. Peters would constitute grave misconduct. That allegation wasn't made anywhere in the moving papers.
In your response, did you indicate that it was Mr. Green that made that request?
Yes, I did.
Okay, I think he's able to respond to that. So I'm going to overrule your objection.
But that's an argument that should have been brought in the motion because he had due diligence, Your Honor, in order to verify the facts and look at the video in order to see who did it. He can't ambush us afterwards because then we don't get a chance to respond to that argument. That's unfair. He has, as I said, I think he has the ability to respond to your documents, and so I'm going to overrule that objection. Thank you. Okay. The second objection is there's a new argument in plaintiff's reply that fundraising activities by the PCPA is ex parte conduct and is about this lawsuit. That was nowhere in the moving papers. This is an ambush. Plaintiff or defendant Green did not have a chance to respond to plaintiff's arguments. This is in the reply on page 4, lines 18 through 22. And they even admit that this is unrelated to the ID badge in the reply. Mm-hmm. And they say in their moving papers that this whole lawsuit is about the ID badge being requested under the Public Records Act.
You have a response to that?
Your Honor, we raised the entire interaction in our motion. We submitted the video as counsel indicated, so this entire interaction was improper. The ID badge is the central legal question in this lawsuit, but to say that it's okay to have ex parte contact with an opposing adverse party who's represented about the fundraising that they have engaged in to fund the lawsuit, that is related and it's included in the video that we presented to you. So that's properly before the court.
Didn't they use public email on that?
Your Honor, the video isn't the moving papers. There is no mention in the facts in the motion or anywhere in the motion about the PCP, about fundraising activities. There's no mention about fundraising activities in the response. This is a brand new argument. This is an ambush. And this is more egregious because plaintiffs are saying, look, this is bad faith litigation. This is an ambush. Their whole argument is an ambush, an impermissible ambush. And that's impermissible bad faith litigation. They needed to give us a chance to respond to that in the response. They didn't do that. This should be stricken from the record.
Ms. Freeman, I've been not asking you, do you have anything that you'd like to add to this argument?
Doesn't need to.
If you're asking me,
yes. I hope I got your name right.
The video itself obviously was submitted as evidence in support of the motion. All of that evidence was before the court, and in fact, the video was one of the central pieces of evidence, including and primarily all of the speech that took place on the video. So I think it's facetious to say that somehow statements that were made in the video weren't before the court during as part and parcel of the moving papers.
Yeah, but that needs to be tied into the motion. That needs to be represented in the motion somehow. You just can't throw in evidence and then later come in and say, oh, I'm going to cherry pick something out of that evidence that's supposed to be part of my motion. I didn't know that. There's no way that Mr. Green or plaintiff's or defendant's attorney knew that that was supposed to be part of the motion if it's not included in the motion itself. There's no reference to it about that part of the video, and that should be stricken. That's unfair.
I will just point out, Your Honor, that on pages 3 and 4 of the motion in the facts section, it does specifically outline the interaction with Mr. Peters and Mr. Thomas, where Mr. Thomas was asking him about the fundraising activities and then calling him a liar. That's on pages 3 and 4 of the moving papers.
So the information that was attached to the moving papers is part of the information provided to Mr. Thomas and his client, Mr. Green. Because of that, notice was appropriate. I'm going to overrule that objection.
Yeah, and I think also that motion says that Mr. Hoopy was present.
So go ahead, Mr. Thomas.
So then I need clarification before we move forward of whether Mr. Nicholson is speaking as a witness based upon his multiple declarations, because Mr. Nicholson is setting out facts. So he's saying that this was in the video, correct? And the video is identified as true and correct and submitted into evidence under Mr. Nicholson's declaration. So this motion is based upon Mr. Nicholson's declaration and supplement. Mr. Nicholson keeps going back to the motion and saying, or going back to the video and saying this is in the video. And we need clarification on whether he's speaking as a disinterested lawyer or as an advocating as a witness, because this implicates RPC 3.7. And it can just mislead the tribunal. This has been briefed in the response and in Mr. Green's declaration and objections. We need an answer to this. Mr. Nicholson, what are you doing? Are you acting as a witness because you submitted the declaration as true and correct? You could have had somebody else do that. You could have had your client, Mr. Peters, do that. You could have had somebody else in the PCPA that did that. You don't have any personal knowledge about this. So are you acting as a witness or are you acting as a lawyer?
Your Honor, do you want me to answer his question directly to me, or?
Yes, please, go ahead.
So the video shows what it shows, and that's the evidence of what happened. I've submitted the video. Your Honor has indicated that you've reviewed it. There is, contrary to what's stated, there is actually a declaration by Mr. Peters that was submitted, so the video is not the only evidence we're relying on for what happened. Mr. Peters was there. But as far as this, what happened in the video, there's no dispute that the video shows what it shows, and so I'm citing the video and telling the court that it can do so, and the facts are evident from that.
But, Your Honor, a witness needs to have personal knowledge of something. Mr. Nicholson doesn't have any personal knowledge of what happened in the elevator. He has no way in order to testify whether that's true and correct. And this motion is based upon what happened in the elevator in that video. If you look through the motion, it is replete with citations to the video, including Mr. Nicholson's claim that I demanded Mr. Peters' ID badge. That is based upon the video.
That's also based on Mr. Peters' declaration. It states
Mr. Nicholson, please don't interrupt me because you don't have first-hand knowledge. Please explain how you have first-hand knowledge.
Okay, so, Mr. Thomas, you don't get to tell him not to interrupt you. That's something I get to do. So, you had a pause. He began to respond to you. And so we're going to behave ourselves. So here's the issue for me. It appeared that the question that you're raising has to do with the declaration concerning, and I guess maybe the way I read it, and maybe I'm wrong, but I read it that he was certifying the video to be a true and correct copy of whatever he pulled down, I believe, from the published video. That's how I understood it. Am I wrong on that?
Is that question to me, Your Honor?
Yes. I'm sorry, I should be more clear.
I have certified that I made a copy of Mr. Green's YouTube video from that day. That's all that I've testified to, that it's a true and accurate copy of the video that's online. And the video shows what it shows. And I think the video is evidence of what occurred that anyone can view.
Your Honor, that can't be true because he's using that to establish factual basis for what happened in the elevator. He uses that video to say that I demanded Mr. Peters' ID badge. He has no firsthand knowledge that that happened.
Okay, so I believe that my understanding of the declaration was that he was establishing a foundational basis for that particular video. And I do believe the video speaks for itself. My view of the video and that evidence will be used in ultimately making the decision I make. So I believe that takes care of that matter. Go ahead, Mr. Thomas. Anything further?
Yes, I'll move into the substantive arguments then, Your Honor.
Thank you, please.
There's multiple misrepresentations in the video, and in fact, this is fraud, or in the motion, and this is fraud upon the court. Mr. Nicholson is making misrepresentations and asking for money in the form of attorney's fees in order to compensate him for his misrepresentations. That is fraud upon the court. This motion should be denied. The first misrepresentation is that in the motion it says that I demanded Mr. Peters' ID badge in the elevator on January 24th, 2020. That's on the motion at page 3. That never happened. And in fact, that sentence cites to the video. The video conclusively shows that I didn't do that. And in fact, Mr. Nicholson pivots in his reply and he says, okay, well, it may have been Mr. Green who said that. So that's a misrepresentation. Either I said it or I didn't. It's a binary proposition, Your Honor. And the fact of the matter is Mr. Nicholson's evidence, which he testifies is true and correct, does not show that I ever said anything about Mr. Peters' ID badge. The second misrepresentation is that in the motion it claims that Mr. Hoopy was in the elevator with Defendant Green and myself, and that's at the motion on page 3. Mr. Hoopy wasn't in the elevator. Mr. Nicholson never even bothered to ask Mr. Hoopy whether he was in the elevator. Mr. Nicholson's just spouting off stuff in order to try to retaliate against Mr. Green and myself. This lawsuit's been going on for nearly 7 months. Plaintiffs haven't even sought discovery. Plaintiffs haven't sought summary judgment. This is an issue of law that plaintiffs should have moved on. And instead of litigating this case, plaintiffs are just attacking Defendant Green and myself. That's impermissible, and it's based upon a misrepresentation because Mr. Hoopy was never in the elevator on January 24th, 2020. Third, the reply shifts the argument and blames Mr. Green for the first time and attributes Mr. Green's actions to Mr. Thomas. So in the reply, instead of saying Mr. Thomas demanded Mr. Peters' ID badge, it says that Mr. Green demanded Mr. Peters' ID badge. This is problematic for 2 reasons, Your Honor. First is the protective order is only on myself. If plaintiffs really thought that Defendant Green made some sort of action, they would seek a protective order against him too. The protective order is worthless and futile if Mr. Green made the actions and it's only prohibiting me from talking to the plaintiff's PCPAA. So that's a misrepresentation. Either I did the action or I didn't. That's what's in front of this court right now, not whether Mr. Green made the action, because all the relief is based upon me personally paying sanctions and me a protective order. So the second issue is they're only trying to sanction me. They're not trying to sanction Mr. Green. If you look in the order on their motion, it clearly says that they're seeking protective order and sanctions against me. So that's a misrepresentation. If they wanted it to be against Mr. Green, they would have put it in the moving papers, and they had every opportunity to do so. They're coming to this motion with unclean hands. So then let me go into the First Amendment argument. The First Amendment affords me or Mr. Green in arguendo any opportunity to ask Mr. Peters about his identity. The First Amendment guarantees freedom of speech to the government, and the whole point of the First Amendment is in order to protect people from the government. The PCPA is the Pierce County Prosecuting Attorneys Association. It is a group of 100 governmental lawyers who are deputy prosecuting attorneys for the Pierce County Prosecuting Attorney's Office. They are government employees. Mr. Green or I, if we did ask for the ID badge, had every right to, because we were concerned about malfeasance. Why wouldn't a government employee identify themselves? That's a basic duty that they have to the public, so that the public trusts them and knows that they're performing their job opportunities properly. And in fact, that's also illustrated in the Pierce County ID badge policy and in the Pierce County courthouse building and courthouse policy. Anyway, they have to have their ID badges on the outermost part of their clothing. That's so if the public is walking by, the public knows who they are. Mr. Peters didn't have his ID badge on the outermost part of his clothing. And in fact, Mr. Peters tried to conceal his partially visible ID badge during the conversation. We didn't know who he was. This conversation would have never happened if Mr. Peters had his ID badge on the outermost part of his clothing. So Mr. Green and I were protected by the First Amendment for any sort of conduct. RPC 4.2 does not trump the First Amendment. The First Amendment is paramount in this. Second of all, even if this court doesn't want to rule on that argument, this communication was authorized by law. These communications did not involve the lawsuit. Mr. Green was asking about his ID badge under the ID badge policy. That isn't an issue in this lawsuit. Moreover, none of the communications involved the Public Records Act. There was no demand under the Public Records Act for Mr. Peters' ID. That's what this lawsuit is about. Plaintiffs are trying to stop Mr. Green from receiving ID badges under the Public Records Act, specifically Mr. Cornelius' ID badge. There is no mention about receiving the ID badges under alternative methods. For example, under the Pierce County ID badge policy. So it needs to be put in context. Mr. Nicholson loves to come to this court based upon his own testimony and say, look, this is just all part of the lawsuit, and he doesn't explain it. Like the fundraising activity, he says that's part of the lawsuit. He never explains how first of all, what fundraising activity it was, because in the video it doesn't mention any specific fundraising activity, and two, how this non-specific fundraising activity is a part of the lawsuit. So this is just retaliatory. There's no basis for this. RPC 4.2 only applies if it's a communication about the lawsuit. And then furthermore, there's an exemption to that if it's authorized by law. It was authorized by the First Amendment. Furthermore, with all the misrepresentations that Mr. Nicholson made, he had 2 months in order to vet this before he brought this motion. The incident occurred on January 24th. He brought this motion in the middle of March. He had plenty of time in order to vet these accusations. He didn't. Either this is extremely reckless and embarrassing to him, or this is fraud upon the court. This needs to be denied, summarily denied right now. And this is holding up my attempt to leave this lawsuit. I don't want to be a part of this lawsuit anymore, Your Honor. I'm trying to leave this lawsuit, and Mr. Nicholson is only trying to retaliate against me. This isn't going anywhere. Thank you.
Thank you. Any response?
Reply, Your Honor?
Yeah.
To me, okay. Back again regarding the demand for the ID badge, the video is not the only evidence of that, and I would remind Your Honor that we do have a declaration from Mr. Peters who was present. On page 2 of that, it indicates that Mr. Thomas was the one who asked that question. As far as the issue of Mr. Hoopy being present, I had believed that to be the case. That appeared to be confirmed, at least I thought, because Mr. Hoopy actually sent me an email, and that's attached as Exhibit 3 to my supplemental declaration. In that email, he's describing events, and I assumed that that meant that he had been present for them. If that's not the case, that's not the case. But whether or not Mr. Hoopy was in the elevator is not terribly important to this motion. As far as who the sanctions are against, yes, counsel is right that the protective order and sanctions being sought are against counsel because RPC 4.2 applies to attorneys. So that is what we're seeking. Regarding this First Amendment argument, there's no authority cited for this, that this is somehow a First Amendment protected activity to go up to someone and ask for their ID badge, where you are the attorney representing an adverse party in a case over that exact subject. And as far as this argument that this was permitted by law because of some kind of internal policy that the county has about ID badges, first of all, the county in its discovery responses, which we've submitted with our reply, indicated that the purpose of that policy is so that staff at the courthouse have the ability to get into secure areas, and they need to have their ID badges to do that. The purpose of the policy is not so that every member of the public can go up to any county employee and demand that they show their ID badge on request. And secondly, and I think more importantly, this is an internal policy. This is not a law. This is not a statute or an ordinance or even a regulation or anything that has the force of law. And in Washington, when you talk about things that confer legal rights on people, there's a distinction between something that has the force of law and something like an internal policy directive. This is an internal policy directive. It does not confer any rights on Mr. Thomas or Mr. Green or anyone else. And so that argument also should be rejected. And so unless the court has any additional questions, this protective order should be entered, and we would request sanctions.
Thank you, Mr. Freeman. Again, I'll move to you. I'm not sure whether you have anything to add to this or not, but I'll give you that opportunity.
Thank you, Your Honor. Just briefly, as counsel for another party in this case, and in light of the fact that I am engaged in other litigation where Mr. Thomas is the counsel, I mean, listening to the argument, having seen this conduct go by, and then listening to and reading Mr. Thomas's arguments about his view and perception of how the RPCs do or do not apply to his conduct as a licensed attorney in the state of Washington is very concerning. It sounded like he suggested today that the RPCs don't apply to him as long as he's speaking or saying something that he can say or do anything that he wants, because the First Amendment trumps any sort of professional obligations. And that's a concerning statement to hear from a licensed attorney when we are expected to follow the rules of professional conduct. And this court and the courts of Washington do have the authority and obligation to oversee proper administration of those rules on licensed attorneys, which I agree is a distinction between Mr. Thomas and whether or not any action would have been sought against Mr. Green, who's party non-attorney.
Objection, Your Honor. This wasn't briefed.
Yep, Mr. Thomas, I appreciate your position, but I'm prepared to make my ruling. The reason why I'm cutting you off is, frankly, you're going to win.
Thank you.
In this case, in looking at the facts, I do not have enough evidence to indicate that Mr. Thomas is the one that asked for the identification badge. That is the issue before me that would be relevant to this particular litigation. Now, I do believe that he did ask a question about fundraising, but the fundraising was not specific, and I do not find that that's sufficient enough to raise the issue before me for protection order. The conduct of Mr. Thomas, though, probably if I was an attorney in that situation, I would not have done it myself. That is not the standard before the court. The standard before the court is much different than that. And right now, there is not enough evidence to issue a protection order nor grant sanctions. So the request is denied.
Thank you, Your Honor. I can submit a proposed order with that today.
Yes, please. And I don't know exactly how quickly that's going to be signed. I don't know whether I still owe a signature on a document at this point from the original hearing that we have, but we need to tidy up the court file. Unfortunately, not only did we have some issues regarding the distance and the shutdown of the courts, but of course, I also got COVID-19 in the middle of March and was out of commission. And so I'm trying to catch up a little bit myself. Nonetheless, yes, please submit the order, Mr. Thomas. I did sign the proposed order, and I scratched out the word proposed on the other matter, and that will be submitted to Pierce County Clerk's office.
Yeah, I'm going to need to be, am I going to get served on that order at some point, or are we just going to get a letter in the mail, or what? Anybody?
In order to, I assume you're going to be served, sir, but I'm not sure exactly how that's going to occur. But anyway, that's what's going to be going. It's going to be going to the clerk's office, I assume, but that's not one of the things that I take care of. My staff will make sure that it gets in the court file.
Your Honor,
Clerk's office in Kitsap or Pierce?
Mr. Thomas?
I have one quick, I can let Mr. Hoopy go first. I'm sorry. I have one
It's
quick.
going to be in Pierce County. It's a Pierce County case. Go ahead, Mr. Thomas.
Does this court authorize my withdrawal? Plaintiffs were trying to block my withdrawal based upon this motion.
So now that this motion has been taken care of, is there any continuing objection to Mr. Thomas's withdrawal?
No, Your Honor.
And from the county, Your Honor.
You're allowed to withdraw, Mr. Thomas.
Thank you, Your Honor.
All righty. Thank you very much, folks. I believe that concludes our hearing for today.